Hello and welcome to the Argyle HR Leadership Forum Tech Check 2022. My name is Michael with Argyle. It's great to have everyone joining us today. I have some important information to share with you, and then we'll turn the floor over to our esteemed opening keynote speaker. First, we'd like to take a moment to thank today's sponsors, Beamery, Cloud Services Solutions, Globalization Partners, Workday, and Eightfold AI. Our partners are committed to providing you with valuable content and a great overall experience. At any time during today's event, you can visit the virtual booths from the main agenda page, which include complimentary materials, information, and meet and greet opportunities. Thank you again to our sponsors, Beamery, Cloud Services Solutions, Globalization Partners, Workday, and Eightfold AI. We also welcome you to stay socially connected during today's event. And for those of you who are active tweeters, please use the hashtag ArgyleDigital and follow us on Twitter at ArgyleExecForum. Also, be sure to follow Argyle on LinkedIn for special announcements. I'd like to take a moment to touch on our content neutrality policy, which we've curated based on the feedback we received over the years from our members. We've worked closely with our speaking faculty to ensure that you receive a set of balanced and neutral viewpoints during the session today, and we appreciate our members' support of this policy. Finally, and most importantly, we want to hear from you. So during each session, we encourage you to submit your questions and comments in the Q&A box on your screen. Following each presentation, we've set aside time for our speakers to weigh in on your questions. Thank you again for joining us today, and let's get started. Without further delay, I'd like to introduce Scott T. Lashway, partner and leader of Manat's privacy and security practice. We're excited to have Scott with us for his opening keynote presentation titled Data Protection in the Workplace, Compliance Update 2022. Scott, thank you so much for being here with us today. Welcome, and over to you.
Thank you, Michael. And it's a pleasure to be here with everyone. Good morning. I'm here in Washington, D.C., and I'm going to give you an overview in the next 30 minutes or so of what is on the forefront of all of our minds in the data privacy and related security space from the lawyer's perspective. Obviously, this is a space that has been getting more and more attention from day to day and week to week relative to the geopolitical environment globally, relative to the threats that data faces globally, and relative to very significant regulatory developments over the last 3 to 4 years, following on what's been a series of regulations of security and data since the 1980s. So this is not a new area of practice, but it's gotten renewed attention as navigating the regulatory complexities has become more challenging, and our reliance on data, the infrastructure that moves it and keeps it safe, has become more complicated and more prevalent. So let me begin with a topic that may be at the forefront of all of your minds, which is California. So California and its CCPA has been a leader in the United States at the state level of regulating personal data. And until recently, employee data and business-to-business data was exempted largely from the CCPA's application. The CPRA was an amendment to the CCPA, so it was a statutory amendment that coincided with the development of underlying regulations and the proposal of those regulations to further enhance what the CCPA will regulate going forward. An important part of the CCPA when it was first enacted was that employment data and business-to-business data was exempted from the CCPA's application and all of the rights and obligations that come with it until January 1st of 2023, when the amended CCPA, commonly referred to as the CPRA, comes into effect. The California legislature for a long time was thought to be in favor of continuing that exemption for those particular data sets. And through its inactivity at the end of its legislative session in August, we know that employment data and business-to-business data will become regulated by the CCPA, on January 1st of 2023. And there's a slide in front of you, slide 5, which gives you a general overview of the practical implications of this that I'll review quickly. We've been asked by clients and told by some that they may be too late to try to comply with the CCPA and its employment obligations. And we always turn to the old proverb that the best time to plant a tree was 10 years ago, and the second best time is today. So it's never too late to comply with a regulatory regime. Here we have roughly 3 working months before your controls as applicable need to be reviewed and tuned up to make sure you're handling employment data and business-to-business data appropriately. But in effect, what will take place on January 1st is that all the CCPA rights will become operational relative to those 2 types of data. So the rights to know, to correct, to delete, to opt out of the sale or sharing for advertising of personal information, the right to restrict use of sensitive personal information, the right not to be retaliated against, will all be applicable to employment data. Now, some of these rights already exist under applicable employment laws. I'm not an employment lawyer. I'm a data and privacy and cyber lawyer, but the CCPA carries with it a little bit of a different context in the form of rights for investigation, rights for AG and CPPA, that's the enforcement agency of the CCPA, and the rights for employees or the opportunity for employees to use the CCPA in ways to weaponize privacy statute to protect maybe employment status. So things to be thoughtful of, and you've been down this road before, is how can employees use this to their advantage and to the detriment of a company? So easy example is an employee who may be under extra supervision or maybe in the process of being terminated, catches wind of that and starts exercising their rights under the CCPA to know, correct, delete, opt out, restrict use of sensitive personal information, and say, well, you can't fire me now because that would be retaliating against me as I probe about your compliance with the CCPA. Like I said, we've been down this road before with application of other laws outside of the data context, but this is another one, and it relates to typically our basic handling of employment data. Employment data here would include not just data related to the employee's employment at the company, but it would also relate to applicants to the company and data probably within the HR file and outside of the HR file related to that person's relationship with the organization. So while some companies have been able to take more restrictive views on what employment data is, maybe it's just what's in the HR file or the personnel file maintained by a manager, there are arguments that will be tested about whether employment data extends beyond that into the world of email and note-taking and conversations. So here's a question, and I'll try to take these as they're relevant to the discussion. How do you see data rights evolving in the future? Will it truly protect the individual or give the seller an advantage? So generally speaking, I think data rights will continue to evolve as we've seen with the European GDPR with California, meaning personal information, that which identifies a particular individual or household, will have greater protections under constructs similar to either California or the GDPR. And there'll be key differences amongst these laws here in the US. Some may require affirmative consent. Some may require affirmative consent with knowledge about the use and collection of that data. And some may just grant the rights to opt out or rights to know based on affirmative inquiry from the data subject. I think those are generally the models that you'll see going forward. the right to, the definition of consent is a complicated history under the U.S. law. Under U.S. laws generally, dating back to roughly 100 years ago in very different contexts. HIPAA, as many of you know, has this consent built into it. HIPAA is one of our older privacy laws here in the U.S., and we are not going to be surprised to see consent baked into future state laws, possibly even a federal law, though I think California is making it more difficult for a federal law to be truly enacted and preempt state laws. And so I think you're going to see these same basic models being proliferated around the US. I would not be surprised to see another 2 or 3 states come online with privacy laws, including laws that would regulate employee data in the next 18 to 24 months. I also would not be surprised if the development of privacy laws does not necessarily follow the political divides in the US between what are commonly referred to as blue states versus red states. We've seen blue states enact laws, we've seen red states enact laws, and we see purple states considering enacting similar laws. So just some practical considerations about California. We need to make sure that we've got privacy notices detailing personal information handling practices set and ready to go in advance. We need to ensure that we're obtaining detailed contractual commitments from third-party recipients of employees' personal information. You know, the sponsors of today's program are companies who have largely spent a lot of effort and time getting out ahead of these types of issues and can help with compliance. But there are a lot of vendors out there who may have different practices or practices that you'll need to probe and understand with respect to your own handling of employee data. And you need to understand the data use cases for employee data and data about individuals at vendors, customers, and partners. This is where the B2B often comes into play. So if you are providing services to companies in the employment space, or you're in the employment or HR space contracting with vendors, that B2B information that is being transferred during the contracting process would arguably be protected under California, and those rights need to be extended. Let me move along to other states that have enacted in the last couple of years, some very recently, kind of industry agnostic privacy laws with Colorado, Connecticut, Virginia, and Utah. So I won't walk you through each of the states. They all are somewhat different. For example, Virginia sitting somewhere between California and GDPR has ideas and concepts of consent built in for sensitive personal information that would typically include health-related information, even if it's health information collected in the course of employment. So if you have a sick employee who has this ailment or that ailment, and this ailment or that ailment diagnoses and health condition is in your employee file at the company for benefits purposes or otherwise, that information often would be sensitive personal information, and there would need to be additional considerations with respect to compliance with that state law. One of the challenges for those of you operating across the country is US laws typically provide these rights to citizens of that state and residents of that state. So if you are an employer, say in the Midwest, and you have a resident of California working for you, the resident's rights to California privacy rights likely travels with that person for at least some period of time. And these are issues that are going to be played out in the courts over the coming years. And so with the work from home situation that we have and the mobility of the workforce that you all have been having to confront over the last 24, 36 months, these types of issues and questions are no longer just related to the tax environment, where is it okay if we conduct business or have employees in this state versus that state? That was always a focus of lawyers and employment considerations about what employment laws would apply. Now we have data privacy protections. That would be another example of things that you need to consider when having a workforce as mobile and as diffused as many of you are deploying. One of the things we're waiting to see here on the right of this slide is we are waiting to see how the scope of the Colorado and Virginia exemptions are interpreted. So we give you an example of a question that has been raised repeatedly with our advisory work. What is an employment records purpose? Is it limited to the employer's purposes? Does it include job applicant information? Does it include benefits administration? For the time being, our recommendations typically are you should interpret these open questions for debate through vague statutory drafting or interpretation or application to your company in favor of the employee, while we all wait for clarification and test that clarification through either enforcement actions or court action or additional legislative activity. With that said, you need to be extremely diligent and thoughtful on whether you're extending, say, rights from Colorado or Virginia or California to employees that are based elsewhere. So if you have employees in a state like Florida and you are a California operator, do you have an obligation or desire to extend those California rights and obligations under the CCPA to those Florida employees? And we think these decisions should be informed and purposefully made. I got a question about security breaches are now commonplace these days. What practical advice can you offer individuals to shore up their online security? So that's like a 4-hour discussion on my part. There are some simple things that we should be focused on with respect to overall handling of employment data, B2B data, and other protected information, both personal information and company resources and assets, confidential proprietary information, IP, financial, strategic business plans, all the things that you all lie awake thinking about at night with respect to onboarding new employees, offboarding employees, and the general maintenance and the building of a corporate culture. It's really important that HR is at the table with respect to privacy and security discussions when we're advising companies to build security committees. HR leadership is almost always recommended to be on that security committee, which is governing overall the health and operation of the organization's privacy and security programs. Cybersecurity and data privacy are not the sole responsibility of the IT department or even the security department. Each of us has an important role to play. There is nonstop conversation in the security industry about the internal threats. And those are internal threats that are caused by employees and contractors with access to our electronic infrastructure. But they're not just internal threats from bad actors. We're all one click away from making a mistake and allowing malware, ransomware, some other virus to get inside of our network. And that mistake can have a cascading impact on the organization and on that particular employee. And so when we think about what practical advice can we offer individuals to shore up their online security, I think some of it starts with the HR function working with legal and security, compliance, or IT. But the two main actors there from our perspective would be HR and legal. They include routine training, and not just training online, clicking through as fast as you can, but human interaction. We provide training to employee basis. There's a lot of lawyers and privacy and security professionals out there that do it. On getting people to understand that mistakes will happen, but it's how we respond to those mistakes. We tell clients that you might not be able to control all of the inbound risk, but you absolutely can control all of your reaction to it. So training is important there. Working with your security professionals to make sure common controls are in place, multi-factor authentication on all email, on all outward-facing applications, on your application to your HR database, whether that be something in the cloud or whether it's on premises. It needs to have multi-factor authentication. And that's not always just typing in your name and getting a code, but there's different controls there that can be deployed. Some of them are not as disruptive to the user as what a lot of people complain about. So those are a couple of practical tips. With respect to your job in particular, I would encourage you to make sure that there are internal privacy policies that are available to employees should they be needed, that would talk about your handling of employment data and how you keep it private. I would encourage you to have at least a working understanding of your incident response plan so that if something happens and the workforce is either prevented from working or needs to be informed, there is at least a plan for discussion. You all avail yourselves of appropriate legal advice to either communicate with that workforce or not. These are just examples, and there's some additional ones in the slide deck, which will be available, I think, as of tomorrow for you to consider. Internal policies that we think HR should be thinking about. Now, many of these are very technically focused, and you don't have to have a computer science degree to participate, but it is helpful to have HR leadership asking questions about these types of written policies, including whether they actually exist. Access management, for example, typically is going to be governing, it's the written policy governing access to the organization's electronic infrastructure and electronic assets. That would include data, that would include where data is stored, that would include bring your own device. Sometimes that's in a different policy or it's embedded. What the organization can and can't do if you bring a personal device into the environment and use it for work purposes. These are all things that are critically important these days. What can the organization have control of or visibility into? In particular, if it's a personally owned device, what policies or consents are needed to surveil those personal devices if they're being used for company purposes? These are all things that HR executives have learned to ask about. You may not have all of the answers readily available because you might not be a technologist, but your legal team and your security team should be able to collaborate with you to ensure that your security policies are accommodating your normal business operations from an HR perspective. One of the important things we think to answer this question is this question about what practical things you can implement to help build a privacy and security centric culture. Is that employees can't be told that cybersecurity keeps the CEO or the board of directors awake at night, but then there's no follow-up to that. It can't be just a talking point at the town hall. It needs to be constantly driven to home that not only is executive leadership caring about this and talking about it, but they're willing to implement controls and training and all of the other mechanisms that foster an environment where you're allowed to safely conduct your work activities for the benefit of the organization in a way that doesn't expose the organization to unnecessary risk. Oftentimes, security in particular can be used as, well, we would implement that control, but it's probably going to get in the way of that group's work. I just got off a phone call with a client on that very issue. But it's okay to change how we work if how we work is going to be better, is going to produce better results for the organization, is going to allow our employees to perform better, and is ultimately going to protect the assets of the organization. A handful of years ago, we got questions repeatedly about whether it was safe to go to the cloud. We still get those types of questions, but they're more informed now. The questions aren't, can we go to the cloud? The questions are, is this the right cloud we should go to? And how can our employees interact with that cloud in a safe manner? Is it okay to be processing HR data offshore? Is it okay to be processing benefits data offshore from a privacy perspective? And if it is, should we be taking extra precautions from a technical perspective, limiting access to that data when it's offshore? Are we implicating those foreign privacy or security obligations by putting it offshore? These questions are informed, they're welcomed, and the answers are not always easy. Sometimes it depends on your organization and what data you want to move. But it's nice to see that the conversation is changing within US and Western companies because of the knowledge that folks like you and the HR side and elsewhere in organizations have learned. For employment applications, we have a right to maintain records per different labor laws. Do you recommend deleting applications if the candidate requests a deletion of records? This is a complicated question from the perspective of which law trumps the other one. So it's a very specific analysis, but generally speaking, that analysis would include if the labor law says you have to retain it for a period of time, the right to delete generally allows you to maintain data for legally obligated purposes. So other reasons why you don't always have to delete is if you have a litigation hold in place because the employee is subject to a litigation hold relative to company litigation or relative to employment litigation. You can't necessarily delete that data, thereby destroying evidence or spoliating evidence in ways that would create other risks. So these are things that need to be tracked. Someone asked, can we get information to keep up with the changing workplace related laws? Is there something online? Generally not. I would say there's a massive amount of ink spilled electronically on evolution of data privacy laws. My own personal view is about 50% of it's not always well informed or accurate. I find too often that some of the white papers being written to summarize these new laws are not always accommodating areas of the law like HR, which require specific knowledge and experience. So we haven't seen yet a place where all of these laws are being succinctly organized and available to you. What types of employee data is landing HR executives in hot water most often? I would say it's not necessarily the types of employment data. I would say it's the handling of employment data. So if for some reason your employment data is leaking out of the organization to a vendor that was not clearly acknowledged to the employees or not understood by the organization, there are cases out there where companies are being sued for operating websites with certain types of tracking technology. It used to always focus on cookies. Now it's focused on some different technology. And I think we're going to continue to see that type of litigation grow with respect to the tracking or use of employee electronic infrastructure or data. I think policies and procedures largely can insulate you from a lot of that risk, but it's an example of things that need to be attended to. So one of the things I just want to talk about, final thoughts, there is an absolute need to protect employee data. The slide deck will give you some of those things like biometric information with respect to employees clocking in, clocking out, or confirming their identity has gotten a significant amount of attention, probably the most amount of attention that's gotten HR execs in that hot water bucket that was just asked about. Retinal scans, fingerprints are all heavily regulated by certain states, Illinois being the most prevalent one. We continue to see biometric data appearing in some of these new state privacy laws as well. You look at the compliance mechanisms there, they're relatively straightforward. They're just often missed or ignored at times. There's a couple of examples in here, and I'm going to hurry up and finish, of things that you can use maybe in your own training. These are things that we've seen where you've got a phishing email You've got another phishing email. And then we talk about incident response preparedness. And we talk about the patchwork of legal frameworks and obligations, all things that try to educate you on a working knowledge of privacy and cybersecurity. I want to thank you all for listening. I'm Scott Lashway from Manat, Phelps and Phillips, and would always be pleased to take your call if you want to ask any of the questions I didn't have a chance to answer. Michael, thank you.
Thank you, Scott. This is an excellent keynote and appreciate you being here. I also want to thank everyone else for joining us today. Now, this session, along with all of today's content, will be available on demand following the event. And Scott, thank you.
Thank you.